Welcome back. There is actually so much going on in the law that I just needed to break the Emily Show into 2 episodes because there is so much to cover. And because I'm not streaming at all this week because I am on spring break spending some time with my kiddos and my family, I just needed to record 2. Are there going to be more filings before these go live? Probably. Why? Because nothing has any chill at the moment. This is the busiest time of year in the cases that I'm covering, and so many of them are getting ready for trial that it's not a surprise that they popped off. So if your question is, Emily, why haven't you gotten 2? Because there are so many things happening in all of the cases that we're covering, and we will get to it as fast as we can. But there's been lots of live court, lots of filings, new indictments, lots of lawsuits. So we're going to get to everything as best we can and break it down as quickly as we can. So today we've got an extra episode of The Emily Show. Let's get into it. I'm legal analyst Emily D. Baker. Yes, also a lawyer. And this is The Emily Show. I break down the pop culture, entertainment, and high profile cases that we're all talking about. I know you want the facts, so let's get into it. Since today we're going to be talking about Diddy and Jay-Z because there is so much popping off in all the Jay-Z cases. Emily, you said the Jay-Z case in New York with him and Diddy was dismissed. It was. And then Jay-Z sued and is suing the attorney who filed that case now in 2 separate states and in 2 different jurisdictions, not just in separate states because one's federal and one's local. And there's new affidavits and shocking new allegations, which if true are going to be really bad, but it's going to take us a while to get to the bottom of what's true. And then in the middle of all of that, there's a ton going on in the Diddy case. I don't see how this trial goes forward in May with a new indictment filed on March 6th. What is happening? And Diddy's attorneys are still fighting over the bill of attainder or more of a breakdown of the case. And I don't know if these are just going to keep coming out in superseding indictments, but there's a new indictment. So let's talk real quick first about the second superseding indictment in the Diddy criminal prosecution. And then we will get into the miasma of lawsuits that is Jay-Z versus attorney Tony Buzbee. So the feds filed a second superseding indictment against Sean Combs on March 6th. That second superseding indictment does not add any new charges, and it doesn't need to. Remember, Sean Combs is charged with a number of things, but the overarching theme of the case is RICO, which is the Racketeering Act, which was used in the past to go after the mafia and organized crime so that you could get to kind of the tip of the spear, not just the people doing the things. And that's what's being alleged here, is that Sean Combs was the tip of the spear and in charge of Bad Boy Enterprises and other business entities, and using those to perpetrate the other crimes that are charged and crimes that are not charged. This second superseding indictment lays out in more detail Sean Combs's alleged behavior towards employees of the businesses and those who witnessed the behavior that we've already seen lined out in the indictments, because naturally, one of the questions is going to be, well, if people were working for these businesses and weren't part of the RICO organization and saw these things, what was happening? Did anyone say anything? And if they didn't say anything, why? And that's where the second superseding indictment goes, breaking down allegations that Diddy has used his businesses to sexually exploit and abuse individuals for more than 20 years, including the victims in this case and others that are uncharged. And the newest indictment uses the term forced labor to talk about employees that were forced to work for different Diddy enterprises, working long hours with little sleep, talking about the fact that Combs would force them to engage in sexual acts, and used things like physical force, financial harm, threats of psychological harm, and threats of reputational damage should they ever come further. Some of the exact language they added into this indictment states that on multiple occasions, Combs threw objects at people, as well as hit, dragged, choked, and shoved others. They're talking about his employees, and that on one occasion, Combs dangled a victim over an apartment balcony. So alleging further that if people saw or threatened to report, or he felt like they might report things that they had witnessed, they then had wrath turned around on them with the types of threats we have seen alleged that he carried out against the victims. Now we're seeing allegations that he was also carrying it out against employees who were part of the enterprises that are now part of the RICO case. So more details in the indictment, and I wouldn't be surprised if we see more details come out in the indictment. Remember, under that really broad RICO charge, they can bring up behavior that is not charged, that may well be criminal, but it may be outside the statute of limitations or in different jurisdictions. And they can use all of that to build those patterns of behavior that underlie the organization. And they're going to do that because when you have a victim saying that these are the things that Sean Combs did, and this is how I was in fear, this is the threats and the duress and the physical harm. And then you have others coming forward that aren't victims in the case as charged, that were employees saying, yes, not only did I witness this, but also this is what happened to me so that I didn't say anything. It gives the jury a more full picture. And RICO is incredibly broad, allowing people to come in and testify about things that happened to them, even if those things are not charged crimes in the indictment. So as more evidence comes out, I'm not surprised that the prosecutors are updating their indictment against Sean Combs. And I'm sure we will see more motions about this, and we will see, I wouldn't be surprised if we saw more superseding indictments before this case goes to trial. And as we talk about Diddy cases, we need to talk about that Diddy and Jay-Z case that has now been dismissed. I have talked a bit about the Jay-Z civil case that was going on in California. Originally, Jay-Z had filed that as a John Doe. That's now under his own name, where Jay-Z is suing attorney Tony Buzbee. That's the extortion case where Jay-Z is alleging that the demand letter sent by Tony Buzbee was extortionate, and that letter violates the civil extortion laws in California. So we saw that Jay-Z lawsuit. And then I talked about the fact that there's a lawsuit between Tony Buzbee and Jay-Z's lawyers that was filed in Texas. And we went through all these different lawsuits. Someday I need to pull out the whiteboard, some string, and a map to go through all of these. And now there is another federal lawsuit filed by Jay-Z against attorney Buzbee, his law firm, and the Jane Doe that sued Jay-Z in New York, that case that has since been dropped. Are we all following? So we're going to talk about the new lawsuit, and then we're going to talk about a bunch of filings going on in the California lawsuit that give some more information to the new lawsuit. In the New York lawsuit, there was a lot of back and forth between Tony Buzbee and attorney Alex Spiro, who was representing Jay-Z. There were motions for sanctions and press statements and press conferences, and Jay-Z from the beginning of that suit said that this is extortion, and in fact then came forward saying he was the John Doe that had sued attorney Buzbee in California for extortion. That case has since been dismissed. We also saw that there was a media statement made by the Jane Doe victim in that case, which attorney Spiro went forward saying, look, here's all the inconsistencies in that media interview. This case never should have been brought. We don't think counsel has a good faith basis for it. And the vitriol between the lawyers popped off incredibly quickly. Well, that's not done. So when we take a look at this new lawsuit in Alabama, it is a lawsuit for malicious prosecution, abuse of process, civil conspiracy, and defamation against just the Jane Doe, who was the alleged victim in the civil lawsuit in New York. So let's take a look at what Jay-Z is alleging in this new lawsuit. Then we're going to take a look at what's going on in the California lawsuit that gives some more information about what's being alleged in this Jay-Z suit, because there are huge allegations in this Jay-Z lawsuit that mirror the allegations we saw attorney Alex Spiro making in New York and in the press statements there. So taking a look real quick, this was filed on March 3rd, 2025 against Sean Corey Carter, aka Jay-Z, against Anthony Buzbee, David Fortnoy, Anthony G. Buzbee LP, which is the law firm, and Jane Doe. We're going to look a little bit at the allegations here, but not go through the entirety of the lawsuit on this fine day because, well, there's a lot to get to today. The heart of this lawsuit centers around not only the letter and the demand letter being sent. Demand letters, again, a totally normal part of litigation, happen in almost every civil litigation. Sometimes you might not get a demand letter. It might be a cease and desist, which is essentially a demand to cease and desist, but it is a, hey, have a conversation with us, do this thing, stop doing this thing, or you're going to get sued. That is a incredibly normal part of lawsuits. And I'm very interested to see where the California law shakes out on a normal part of process and where the boundaries are between, is this a normal part of process or is this extortion, and where the litigation privilege meets its boundaries, because we're going to see litigation regarding the litigation privilege. Essentially, this is in anticipation of litigation. Is it extortion? And are there boundaries to those privileges? And that's where we pick up in the fact pattern for this lawsuit, saying, quote, when their initial extortionate demand letter failed to yield the financial windfall they sought, and after, for those of you listening on the podcasting app, that's my italicized, underlined, bolded voice. Hopefully you could tell by the way I read it that that was italicized, underlined, and bolded. After Doe told Buzbee, the lawyer, with whom she had never spoken before the demand letter was drafted and sent, first allegation. Jane Doe, who sued Sean Carter, Jay-Z, I'm going to call him Jay-Z or Jay or whatever, because I'm going to confuse myself if I don't, because we're going to be dealing with a lot of names today. We got to stick consistent. They're alleging that Jane Doe did not speak to Buzbee before the demand letter was drafted and sent to Jay-Z. So where is the attorney good faith basis for the claims if he never spoke to her? And we had previously seen statements by attorney Buzbee that this was a case referred to him by another law firm. You still have to do due diligence. If this is true, this is a problem. And again, remember, lawsuits are allegations and shade. I'm very interested to get to what the facts are underneath the allegations and shade in these lawsuits. I am going to continue to say, if true in this, because there are very big allegations here, but we have seen big allegations in other lawsuits that just go womp womp. Like there are mountains of evidence that all of a sudden aren't even an anthill. And you're like, where'd the mountain go? Which is why I say if true. If true, that first allegation is a problem. But they say that Doe told the attorney after the demand letter was sent that Carter, quote, did not sexually assault her, and that attorney Buzbee, quote, pushed her towards going forward with the false story against Carter, Jay-Z, to make the case better and get them, and now in this it has brackets and said the lawyers and her, more money. Specifically, and these are in quotes, specifically, Buzbee brought Jay-Z into it, end quote. I need the rest of the information. I need the rest of the information where we're quoting that from. They go on to say, Buzbee then went forward with naming Mr. Carter with full knowledge by him as imparted to him by Doe that Mr. Carter had never assaulted Doe and that Doe's entire story as it related to Jay-Z was completely fabricated. If a lawyer knows that, you don't have a good faith basis for a filing, and you might not be protected by the privileges that would normally afford a lawsuit. We'll talk about some of those privileges later. They go on to allege that Doe has now voluntarily admitted directly to representatives of Mr. Carter, Jay-Z, that the story brought before the world in court and on global television was just that, a false, malicious story. This is a massive allegation. They go on to say that Jane Doe admitted that Jay-Z did not assault her, and that indeed it was attorney Buzbee himself whom she met for the first time in a coffee shop in Houston on the day of her malicious false NBC News interview, which is discussed in detail below, they say, who pushed her to go forward with the false narrative of the assault by Mr. Carter in order to leverage a maximum payday. This is what Jay-Z's side has said from the beginning regarding the demand letter. If they can prove this, it's going to be big problems for attorney Buzbee. You cannot use process and legal process without good faith basis, which is why in this lawsuit, they are bringing causes of action for abuse of process and malicious prosecution. They go on to say, to compound this egregious harm, just last Friday, Buzbee and Fortney, the other attorney, their co-counsel, a prominent New York attorney, I don't know why they're not naming them, but like name them, but the prominent New York attorney in the now dismissed action against Carter threatened Carter's counsel, I can only assume that was Spyro, can you imagine that call, to double down with yet another false public statement by Doe if Jay-Z publicly revealed her admissions and Buzbee's misdeeds in Carter's pending lawsuit against Buzbee, which is why we're going to look at the California lawsuit next. So they're alleging that co-counsel threatened more public statements if Jay-Z revealed the admissions. Well, Jay-Z's suing for extortion, saying that this was all made up. So if Jane Doe admits that it's all made up, yeah, it's going to come into the lawsuits. It goes on to say, fortunately, and clearly unexpectedly from their perspective, we're just speculating now, Doe, Buzbee, and the other attorney, Fortney, were met with nothing but righteous resolve at every turn by Jay-Z. And this is where we get really hyperbolic on the part of the lawyers. They say he stood steadfast, publicly decried the lies being put forth against him, and beat the evil conspiracy among malicious Doe and her malevolent, soulless lawyers, driving them back into the shadows from which they came, resulting in the voluntary dismissal with prejudice without settlement of their false and malicious complaint on February 14th, 2025. And while it is strong language, if the things that they allege are true, I don't know if it's too strong for this situation. Because if a lawyer is putting forth bogus lawsuits to try to leverage the media into massive settlements, then what is it if not extortion? And they're not wrong that Jay-Z has been steadfast in his statements about this case. There are rules for lawyers for a reason, because what is alleged here, this should never happen. And the thing that will rile me more than almost anything else is fuckery by the attorneys. This is a profession that you choose that is governed by a fuck ton of rules. I love that it's governed by rules. I love when everybody plays by the same rules. We all know what the rules are. They're all written really clearly. There's a judge that enforces them. I liked playing sports. Then my knees started to hurt and my shoulders were crap and I got old. But society has rules, people. There are rules. And manipulating those rules for personal gain is utmost fuckery. It's why the Girardi stuff pisses me off so much. It's why the Murdaugh stuff pisses me off so much. You have to be honest. You have to adhere to the rules of court. You have to do your job. And you cannot abuse the process in doing it, or the entire system that is built on those rules will crumble. Emily, do you think there should be stronger sanctions for lawyers when they flout the rules? I do. When it's proven, I absolutely do. I think we've gotten to a point where there need to be stronger sanctions to prevent the gaming of the system. But is gaming of the system what happened here? And that's the question I'm going to pose to you, because we have a lot more information filed at the end of last week in the California case, including an affidavit by Jane Doe saying that what's alleged here isn't true. And we need to take a look at that now. Before we take a look at that affidavit, I need to remind you to download the Law Nerd app. We are getting into a gauntlet of trial season, and the streaming schedule, which is normally Tuesday, Wednesday, Thursday, is going to be all over the place as I cover live court. So if you never want to miss an episode of the podcast and you don't want to miss the moments that matter the most to you in live court, get the Law Nerd app at lawnerdapp.com. It's free on iOS and Android, and you will stay in the loop, because there are some long days, and I know you can't attend all of court. But when Donna Adelson took the stand in her hearing, we sent out a Law Nerd alert and said, yo, Donna Adelson's on the stand. And tons of you came into the stream and were like, oh my God, I didn't want to miss this. I know court days are long days, stream days are long days, but we will always keep you up to date with the moments that you don't want to miss in court. Unfortunately, some days in court are so crazy that we can't even send out alerts for every crazy moment, because I just sit there going, what? Wait, what? And if you were with me last week in court, you'll know exactly what I'm talking about. And I know you were there with me in court because you have the Law Nerd app, but if you don't, lawnerd.com. Okay, let's get to that affidavit. This was filed on March 3rd, 2025. The attorneys now representing Buzbee and the Buzbee law firm in California are from the law firm of Sheppard Mullin, which is on the same kind of massive, well-regarded law firm as like a Quinn Emanuel where Alex Spiro works, or a Perkins Coie. We are talking Sheppard Mullin is that type of law firm. And one of their newer partners is lead counsel on this case, whose name you might recognize because Camille Vasquez is now a partner at Sheppard Mullin and is lead counsel for the Buzbee firm and attorney Anthony Buzbee. And we're going to get to a affidavit from Camille Vasquez in this case after we cover the Jane Doe affidavit. You guys know that I record the Emily Show with the Law Nerd members in the background. You can be a member on YouTube or in the Law Nerd Lounge on the app. And the question I saw immediately was, are Camille and Ben Chu not working together anymore? No, Ben Chu also moved to Sheppard Mullin from Brown Rudnick. So Ben Chu and Camille Vasquez, and it seems some others like Samuel Moyniz, moved over to Sheppard Mullin sometime after the Depp heard litigations. Now that the lawyer questions have been answered, let's take a look. This is the declaration of Jane Doe in response to Sean Carter's proffer of new evidence at hearing on defendant's special motion to strike portions of plaintiff's first amended complaint. Emily, you should explain what that is first. I should. I had said in my last coverage of this case that attorney Buzbee, who is the defendant here, had filed an anti-SLAPP motion. Anti-SLAPP litigation goes forward in California before discovery takes off. It can be very difficult for plaintiffs to withstand depending on the case. So in this case, they are at the precipice of that anti-SLAPP litigation. If you win as a defendant in the anti-SLAPP litigation, not only do you win your attorney's fees, but you can also get rid of the case entirely or pare down the case to only certain causes of actions. So it's a much earlier part of the proceeding to cut off proceedings that are considered to be strategic litigation against public participation. And in this case, acting as an attorney and filing a demand letter might fall under the type of behavior that is public participation. You are doing your job. The anti-SLAPP litigation here is something that fascinates me, and we're going to have to do a whole deep dive into it in other content because I'm very interested to see how the law is going to play out here with the interplay between litigation privilege, extortion, and what are the boundaries. Emily, you keep repeating it. I know. The law nerd in me is just like, yes, please. These are legally very interesting, nuanced conversations, but the fuckery that's being alleged here is also drastic. And I want to know all about that too. Because there is not discovery ongoing when you get to the anti-SLAPP litigation, there has been some argument in this case about whether some limited discovery is needed from Jay-Z's side to be able to make their arguments in response to the anti-SLAPP motions. So that's the posture of where we are right now and why we're getting this declaration from Jane Doe in response to the proffer of new evidence at a hearing regarding that motion to strike. And this is the declaration of Jane Doe, which starts with your normal declaration information over the age of 18, have been identified as Jane Doe in the demand letter and in the lawsuit, and was granted permission to proceed under a pseudonym in New York and make this declaration under pseudonym for the same reasons, have personal knowledge of the facts submitted therein. The declaration is submitted in support of defendant, the Buzbee law firm, and Anthony Buzbee's motion to strike under Code of Civil Procedure, section 425.16, that anti-SLAPP motion. On Friday, February 21st, 2025, I was approached at my home by two individuals, a woman and a large man. They cornered me on my front porch and told me they are investigators working with an attorney on behalf of Jay-Z. They asked if I would be willing to sign an affidavit stating that my claims in the New York action were false. I refused. They also asked me if Mr. Buzbee sought me out as a client and whether Mr. Buzbee offered to pay me to pursue a false claim against Jay-Z. I told them that neither of those things ever happened, and I asked them to leave me alone. I felt intimidated and terrified at being confronted by these two individuals on my doorstep, and they knew my name and home address despite me being anonymous in the New York action. I also understood that investigators approached my father and my mother multiple times. Two investigators approached my father and my mother as my father was picking my mother up from a medical appointment, asking them similar questions about whether Buzbee had paid me and requesting that they sign affidavits stating that my claims were false. My father was separately approached later at a gas station, and my mother was separately approached at a store. Being followed in your personal life is going to freak out most people. In all instances, it goes on to say, my parents refused to sign any affidavits, denied the investigators' claims about my case and Mr. Buzbee's conduct, and asked to be left alone. It is very alarming to me that Jay-Z's agents are looking for me and now know my whereabouts. Fear of intimidation and retaliation from Jay-Z and or his associates or fans is one of the reasons I chose not to pursue the New York action and instructed my attorneys to dismiss it. Although I ultimately chose not to pursue them, I stand by my claims in the New York action and believe that I had a meritorious claim against Jay-Z. And then she goes in to line that out, and I'm going to sanitize that a bit. But in sum says, quote, in September of 2000, when I was approximately 13 years old, I attended a party at a house in New York where both Sean Combs and Jay-Z were present. I saw and recognized both men at the party. At the party, I accepted a drink and began to feel lightheaded, and then gets into the rest of the claims and the lack of consent and the age. In 2024, I signed up as a client with the AVA Law Group. AVA Law Group partnered with the Buzbee Law Firm to pursue claims against Diddy and others, and my case was referred to the Buzbee Law Firm as a result. There's nothing unusual about that. It happens in law all the time that a client will go into a civil firm of some sort, and that civil firm either doesn't handle that type of case, doesn't handle that type of case in that jurisdiction, or thinks another firm is better. In some cases, there are fee sharing agreements with that the clients should always be notified of. Sometimes there's referral fees that the clients should be notified of, but it's not uncommon that a firm might take in a case and then refer it to another firm. But not the case, as Jay-Z alleged, that the Buzbee firm went looking for this client. However, I think there might be an argument that because the Buzbee firm said, if anyone has claims like this, you can call us, that maybe there's a loose claim of that, but not a direct claim of that. It goes on to say that several attorneys from the Buzbee law firm interviewed me extensively, including Anthony Buzbee. I authorized Mr. Buzbee and the Buzbee law firm to send a demand letter to Jay-Z and to initiate legal proceedings against him in the New York action. I ultimately decided to dismiss the New York action because I was frightened by the reaction of Jay-Z and his supporters and the likelihood that I would have to be publicly named and subjected to public attacks. My criticism of this is that the attorneys should have made this plaintiff well aware of what pursuing civil litigation could look like. It doesn't mean it's right that it looks that way. It doesn't mean that it's okay that people go real world with people. You know how I feel about that. But there is no service to your client of not letting them know what the world actually looks like, not what we would prefer the world to look like. And I would have hoped, and I do hope, that these attorneys sat down with this plaintiff and went through the worst case scenarios of what bringing a very public lawsuit would look like, and the fact that you will have to be named at some point. If you are a plaintiff in a lawsuit like this, you will be identified at some point. You can forestall that point for as long as possible publicly, but even if it is to the attorneys and the defense, that Constitution of ours here in the US says that you have the absolute right to confront. And while we normally see that construed in the criminal context, there is so much case law that goes to the civil context as well. If this case went to trial, an accuser or a plaintiff would have to get on the stand in open and public court and testify to what happened. So at some point, if a case goes to trial, who an accuser is or who a plaintiff is will be made public. There is no way to go through a civil lawsuit without being disclosed to the other side, even if not publicly, because if the case settles after depositions, you've still disclosed yourself to the other side. That was always a possibility and a requirement. I worry that attorneys do not adequately prepare plaintiffs for what this could look like, worst case scenario, because they hope that the case will settle. And most cases do settle. But I still think people should know, because if they want to opt out, it might be better to never opt in for that particular plaintiff, even if it means that they never bring their claims. And that is a very difficult decision to make if you don't have full information. I could rant about this forever. You know how I feel about it, and I won't. I don't like that the reality that plaintiffs face and can face in cases is that if those cases take off on social media, people can be subject to harassment, to real world harassment, and that things aren't always smoothly allowed to play out in court. However, when cases are getting covered so publicly, sometimes even if you are at the end of the day vindicated, if the court of public opinion has already gone the other direction, it can be impossible to rectify. So it makes it a difficult situation for anyone dealing with civil litigation to try to wait for the claims to play out in court. And I think we saw a lot of that in the media with the Johnny Depp Amber Heard case. We saw how much the media had decided and still has decided who the winner of that case was. And it's not who actually won that case. But it's very difficult to wait for things to play out in court. And I wish I knew what a better answer was for that. Claims have to be evaluated. I also think people should be able to pursue their rights without being harassed. But then if you're pursuing claims that are reputationally damaging to someone else, where are the boundaries of their rights? And this gets into the difficulty of high-profile litigation. And I think it's why we're seeing so much high-profile litigation turn into a lose on all sides for everyone. And I worry particularly in this case that a Doe plaintiff was not made fully aware of what this could look like in reality. In this declaration, it seems that that was the biggest consideration, where Jane Doe says, Emily, before you soliloquied, we were in the middle of a sentence, yes. Where the affidavit says, I ultimately decided to dismiss the New York action because I was frightened by the reaction of Jay-Z and his supporters and the likelihood that I would have to be publicly named and subjected to public attacks. Jay-Z and his attorneys made numerous public statements attacking the veracity of my claims, and I am informed and believe that he sent investigators looking for me. I understand that even my attorneys have been sued by Jay-Z. I was not prepared to undergo years of attacks, intimidation, and harassment, and ultimately chose to dismiss my claims after certain negotiations among the attorneys involved in the New York action. And that makes sense to me. I am sure there are people that do not believe this plaintiff. There are, I'm sure, people who do believe this plaintiff. These claims never got to play out in court, but they're now going to play out in court because there is a defamation suit and there is an extortion suit. So even though this Doe plaintiff wanted to opt out, at this point, it's going to be impossible because Jay-Z has now sued her and is suing her lawyers. And if truth is your defense to a defamation suit or to an extortion suit, it means these claims are going to have to be vetted out in different forms unless the cases settle. And it's unfortunate that civil litigation subjects people to real-world attacks, intimidation, and harassment. And for the legal wrangling going on in this case, we need to take a look at Camille Vasquez's affidavit. All right, this was filed on March 3rd, 2025. It's the declaration of Camille Vasquez in support of special motion to strike and in response to proffer of quote-unquote new evidence by Sean Carter. So you get the normal affidavit-y things at the beginning. I'm now heartbroken that California does not sign their affidavits with further affiant saith not. Once I discovered that was a thing in South Carolina, I'm never letting it go because I want everything to be signed with further affiant saith not. But we've got Camille saying that she is a partner at Shepherd Mullen and if called as a witness could testify to the following, quote, on Tuesday, February 25th, 2025, a hearing was held before the above entitled court on the Buzbee party's special motion to strike, the anti-SLAPP motion, against the complaint filed by Sean Carter in the above captioned action. At the hearing, counsel for Carter indicated to the court that his office had just that morning come into possession of new evidence material to the motion and requested a continuance of a few days to allow that evidence to be presented to the court, proposing that the motion could proceed with a hearing on the following Monday, March 3rd. Counsel for Carter also suggested that the evidence might indicate that the demand letters underlying the action were sent without authorization. Well, now that we've gone through the other lawsuit, we know what they're talking about because they allege in the lawsuit in Alabama that, in fact, Jane Doe didn't talk to Buzbee or authorize the demand letters be sent, but Jane Doe's affidavit says that she did. They go on to say that the court proceeded with the hearing, but indicated that Carter could file an application to augment the record on the motion. 3 days later, on Friday, February 28th, a meet and confer was held via Zoom between my office and counsel for Jay-Z. During the conference, counsel for Jay-Z proposed a schedule under which Jay-Z would file an application to add new evidence on Tuesday, March 4th. We asked counsel to describe the new evidence that would be the subject of the application. Counsel indicated that she was unable to provide any new details about such quote-unquote evidence, but that she expected to have more information the following Monday. Accordingly, the meet and confer was moved to Monday at 10:30, the date previously suggested by counsel and the continued date of the hearing on the motion. If we had just done it the way I said, we wouldn't be doing this twice. On the morning of Monday, March 3rd, counsel for Carter advised us via email that she needed to postpone the meet and confer to the following day. To date, 6 days after Carter's counsel represented that it was in possession of quote-unquote new evidence that would materially change the court's analysis of the motion, no further description of the quote-unquote new evidence has been provided. In the intervening time, the Buzbee parties have been provided with a declaration from their client Jane Doe in the underlying case that was filed against Carter in New York, which responds to the proffered quote-unquote new evidence and is being submitted to the court currently herewith. And that is what we just covered. And of course, the litigation hasn't slowed down from there, and the investigators who purportedly spoke to Jane Doe in this case all filed declarations. So let's take a look at those together, shall we? These are a first look for me because I just grabbed them as I was recording because I'm like, I bet there was something, and there sure was. On March 5th, the first declaration is from the investigator Ian Pillinger. It is not about the conversation with Jane Doe. It is their digging into her background as they understand it. Because she is a Jane Doe, there is no way for me to confirm if they have pulled court records, arrest records, and mental health information on the right individual or the wrong individual. So I am not going to go through what they line out in here, but it is this investigator's breakdown of what they say they found in family court filings, in criminal records, in records that are in family court that touch on mental health, past history of assault and accusations connected therewith, as well as child custody disputes. And that I am not getting into because I can't confirm that they are looking at records for the right person. And what I very much want to see is the conversation that they say they had with Jane Doe. Now we're taking a look at the declaration of Charlotte Henderson in support of the application for additional information. This is one of the investigators that spoke with Jane Doe, saying, on Friday, February 21st, along with investigator James Butler, I met with plaintiff Jane Doe, the person on whose behalf defendant filed the lawsuit captioned Jane Doe versus Sean Combs et al. And then they put the case number, that is the New York case. To protect Ms. Doe's privacy and identity, I'm not disclosing here her name or other facts that enabled me to conclude the woman I met was, in fact, Ms. Doe. And that is going to be needed in this case because this is somebody who filed the case privately. However, we have a declaration in court from Jane Doe saying investigators came and met with me. So when you have investigators saying we met with her and then you have her saying investigators met with me, I think those investigators that met with her have connected the same person based on Jane Doe's filing from the Buzbee attorneys. And I'm glad they didn't put it in here. They talk about where they met with Jane Doe and said Ms. Doe, Mr. Butler, and I were the only people present. Throughout our discussion, Ms. Doe appeared calm and at ease. She maintained a natural demeanor and engaged in conversation freely. They say Doe's body language, including her nodding, relaxed posture, and steady tone of voice, reinforced that she did not feel scared or intimidated during our interaction. At no point during our interaction did Ms. Doe request to be left alone. During our conversation, she told me, among other things, the following facts. I wonder if they asked her if they could record this, and I wonder if this is recorded. She said that she saw an advertisement on Facebook for the AVA law group firm concerning Sean Combs, and that group referred her to Tony Buzbee. She said she met with Tony Buzbee for the first time in Houston, Texas. He paid to fly her there. Their meeting to discuss this case took place when Doe flew out for an interview that Mr. Buzbee had arranged for Ms. Doe to give to NBC News in Mr. Buzbee's office. Well, that's new information. Why would Buzbee have arranged for that interview? Jane Doe stated to me that Mr. Carter did not sexually assault her. She stated to me that she originally told Mr. Buzbee she had been assaulted by Sean Combs and that a world-renowned female celebrity was also present during that assault, and that Buzbee suggested that she claim that Carter also assaulted her. Jane Doe stated Buzbee brought Jay-Z into it and that he was the one that kind of pushed me towards going forward with him, with Jay-Z. Jane Doe said that Mr. Buzbee asked if Mr. Carter had been at the party, and Doe told Buzbee that Carter was at the party, but she told me that Mr. Carter did not take part in the assault. She confirmed the following regarding Mr. Carter during our interview, quote, Jay-Z had nothing to do with this, correct? Right. Other than that he was at the party that you were at, so I mean, he did not assault you. No. He was just there, but he didn't have anything to do with any sexual acts towards you. Yeah. Jane Doe said to me that lawyers at Mr. Buzbee's law firm told her that if she pursued Mr. Carter, she would get a payout. She said to me that shortly before Mr. Buzbee dismissed the lawsuit against Mr. Carter, Buzbee told Jane Doe that Carter was threatening. What? Doe said to me shortly before Buzbee dismissed the lawsuit against Carter that Buzbee told her, Jane Doe, that Jay-Z had threatened to kill her in response to her lawsuit and could come after her. Upon hearing that, Doe agreed to drop her case. Doe stated 4 times that Carter did not assault her. After Doe had voluntarily and consistently affirmed this, we inquired whether she would be open to signing an affidavit reflecting what she told us. She responded by saying, but how does this help me? And then that was declared under penalty of perjury. Oh my. Well, I can understand if both investigators, and I don't know if this was recorded in any way, shape, or form. I imagine that it probably was, but I do not know that. That is my speculation. If both investigators are saying that this is what Jane Doe said, and then the lawyers on the other side have an affidavit that says something completely different, I can understand why Jay-Z's attorneys are pushing to have this witness testify. Do we need a deposition here, or do we need this witness to come into court and under oath in front of the judge testify as a part of this anti-SLAPP hearing? Oh boy. The next affidavit filed in this case is filed by investigator James Butler, and his affidavit mirrors the affidavit that we just read, reiterating exactly what was said, that it was just the 2 investigators in Doe, that she said multiple times that Jay-Z did not assault her, and that she refused to sign an affidavit saying, but how does this help me? I can understand, with seemingly and alleged inconsistencies of a staggering nature, why the attorneys from Jay-Z's side are saying, before we go through this anti-SLAPP motion that can dismiss the case, at the end of an anti-SLAPP, a case can be dismissed with prejudice. Before we get to that, we need to have this individual testify. There are a tremendous amount of serious allegations in these myriad of civil lawsuits. Allegations of wrongdoing of a horrific nature by Sean Jay-Z Carter, that in the affidavit from Jane Doe filed by attorney Buzbee's lawyers, she says she stands by. And then there are allegations of absolutely incredible misconduct by an attorney, saying that the attorney told this individual to go forward with these. The allegations are that the attorney manipulated this for a bigger payday. And we don't have an affidavit from Jane Doe. We have the recitation from 2 investigators. And it's going to be very hard to get to the bottom of this without the depositions of Jane Doe. But remember, those anti-SLAPP motions take place before discovery. And I can understand why Jay-Z's side is pushing for the court to hear from this individual who's a witness in the California case before deciding a motion that can be dispositive of the case, when you have 2 completely different stories and allegations of attorney misconduct. It's going to be very interesting to see where all of this goes from here. Let me know if you want me to follow everything going on with these Jay-Z civil suits. I haven't seen as many headlines about them recently, but I have a feeling, Lawnards, that you are as interested in what is going on as I am, because again, how is this all going to move forward? And what are the boundaries of extortion in the practice of law, I suppose? So With that, on this extended special episode, thank you for being here. Thank you for being a Law Nerd. Don't forget to get the Law Nerd app. Take care of yourselves, and may the odds be ever in your favor. I will see you live next week. Lots more court to get to. Bye for now. Thanks for joining me. If you enjoyed this episode and don't want to miss updates on your favorite cases, you're going to need the Law Nerd app at lawnerdapp.com. That way you can stay in the loop on the cases that matter most to you, and you never know when you're going to catch feelings for a new case. So make sure you get it for free on iOS and Android. Thank you for being here, and thank you for being a Law Nerd.